With 37% of the state's students, New York City gets only 34% of the state's school aid. What does this mean for the city and its children? It means children get shortchanged on books, school facilities, and teachers. All this may change as a result of a lawsuit. I'm David R. Jones, president of the Community Service Society of New York, which is part of the group bringing the lawsuit. Today, the Urban Agenda will focus on how we can get more money and a better educational experience for New York City's youngsters. Our guest is Michael Rebell, Executive Director of the Campaign for Fiscal Equity and counsel in its lawsuit to force New York State to more fairly distribute school funding. Mike?
Oh, good afternoon, David.
Well, tell me, what is this lawsuit about? What is, you describe it, I think, as a sound basic education as a sort of the main gravamen. What?
That is the main gravamen, and that phrase is not ours. That's from the New York Court of Appeals. We had a very helpful preliminary ruling from the court in 1995, at which time they held that every child in the state of New York is entitled under the state constitution to what they called an opportunity for sound basic education. And they sent the case back to trial for a judge to determine whether children in New York City are presently being denied that opportunity. That's the main part of our case. We also have a Title VI claim in the case, which has to do with the racial impact of the current...
Title VI, I think for our audience, you have to go back.
Right. That's Title VI of the federal 1964 Civil Rights Act. And Title VI essentially says any action of a governmental agency that has a disparate impact on minorities may trigger the protections of Title VI, and we cleared the first hurdle in getting the Court of Appeals to also say that that issue should be thoroughly explored at this trial.
Now, that would have a particular impact for New York City.
Yes, and the reason it's appropriate for New York City and the reason the court let that claim go forward is just statistically, New York City has 74% of the minority children that go to public schools in New York State. So if we're correct that the present state aid system is unfair to New York City, it's automatically, therefore, unfair to 3/4 of the minority students in the state, and that will trigger Title VI.
Well, given that I expect politicians to be basically in favor of democracy and motherhood, why is the state contesting this claim? If they're not giving us the same equal share, what basis do they have for saying no?
Well, it's interesting you started the question with a reference to democracy and motherhood, because I've been dealing with this matter now for 6 or 7 years, and it astounded me when I first got into it, because in terms of democratic theory, this seems so elementary. What's really going on here is the children with the greatest needs are getting the least resources. And when you bring that to the fore, that is a proposition that I think it is hard for anybody who takes democracy seriously to accept. And, you know, the interesting thing on this, David, is we're not the only state litigating this. There have been lawsuits like this in 44 states. It's been going on for 25 or 30 years, and there have been what people in the literature call different waves of some years. The plaintiffs seem to be winning, the defendants seem to be winning, then the plaintiffs are winning again. The issue keeps coming back. It creates a lot of problems for courts. It creates legal doctrine problems, creates serious remedy problems. What do you do about this? And courts are very hesitant to start dealing with legislators and revamping property tax systems. But I think the fundamental reason it keeps coming back is this democratic imperative that this situation is just incompatible with any basic notion of democracy, and I think it's going to be with us until either the legislatures or the courts solve it. And we're determined that our case in New York State is going to be the vehicle for it to happen here.
Well, I'm sure the defendants in this case have an argument of why it's all right. Can you just, without obviously supporting it, can you give our viewers some gloss of what the argument is against
the essential arguments, there are basically 3 arguments the state makes. One is that funding of education, in their minds, is largely a local operation, and students are dependent on the resources in their local districts. And because there is a great range of local property wealth, with districts like Scarsdale on one extreme and really poor rural districts upstate who may even be worse off than New York City on the other extreme, they say the state aid formula's purpose is to mitigate some of those inequities. And they say the system does that. It may not do it perfectly, but it would be worse if we didn't have the state aid system. So that's their first line of defense. Their second line of defense is to say They see their obligation as only to provide minimum adequate education for students. And in our trial, which has been going on for a good number of weeks now, this issue has come out to the fore. And essentially, it's kind of astounding to me. What the state is saying is, if we have reading, writing, and arithmetic in the old 19th century sense of it, that's all the state's obligated to do. Preparing kids for a computerized world, preparing kids with the skills they really need in the marketplace today. That's beyond their obligation.
But isn't this all thrown into disarray, that argument? The new Regents standards, which everyone across the state is reeling from now, because they're starting to indicate that we don't have a particularly well-prepared public education system for anybody here, is going to mandate before you can graduate from high school that you have to pass a battery of Regents tests. And we're seeing incredible failure rates all the way from the western tier down to New York. How does that all mix if
well,
they are
David,
with the argument?
you've really gotten to the heart of the matter of where we've been in this trial. It is astounding. The state's lawyers, the Attorney General's lawyers, have stood up in open court and said that the learning standards, which as you just mentioned, are now going to be part of the requirement for a high school diploma for every kid in the state. They have used the words aspirational and optimal. They said it'll be great if kids can learn on that level, but the state's legal obligation does not go that high. Their legal obligation is minimum adequate, and this is above minimum adequate. An astounding position for the state of New York to take. And if I could just tell you one little example of the testimony that came out in our case on this, because it was just so astounding. We got the Commissioner of Education, Rick Mills, on the stand and asked him questions on this very point. Are these learning standards aspirational? Are they pegged to a very high level? And he said, no, we've spent years developing this. We've checked with business. We've checked with people throughout the country who are dealing with standards. And we believe these are the basic skills that students need to get a job that will let them support their families. This isn't to, prepare people for Harvard and Yale. This is basic jobs to support their family. After he finished saying that, the attorney for the state, the attorney for the Attorney General, turned to the judge and said, Your Honor, Mr. Mills is giving testimony that's consistent with the plaintiff's position in this case. We ask that he be declared a hostile witness. Unbelievable. My colleague, Joe Whalen, stood up at that point and said, Your Honor, let's take stock of what's going on here. This is outrageous. We have on the stand the Commissioner of Education, who under the New York State statutes is empowered to make educational policy for the state of New York, and we're being told now that he is hostile to the interests of New York State when it comes to education. So this is what's being tried in our case right now.
It's not directly on point with your case, but it's interesting to note we spend a lot of time in the Community Service Society looking at labor trends for workers. And it was brought to me a couple of weeks ago that if you strip New York City out, the state of New York, in terms of job development and growth, is near the bottom of the list of all states in the Union, including below Mississippi. And it goes directly, when you start to parse why this is happening, to the failure of the educational system to prepare kids to take part in all the new growth technology. So you have a very vibrant Wall Street, which is drawing people from all around the tri-state area. But then when you look at the upstate tier, the internet, the new technologies are just not taking off. And the disconnect, I can't understand how the most conservative of the upstate tier could believe that not educating kids to some basic level, I mean pre-calculus, basic English, I don't quite get it, how they expect any kind of economic vitality will remain for the state of New York.
I think you're absolutely correct. And we started this case on behalf of New York City public school children. And it's been very interesting. When the Court of Appeals came out with this doctrine about the opportunity for sound basic education, it automatically converted the case into a statewide case because that constitutional right applies to all students.
Right.
And we've been in touch with many of the interests throughout the state. We've in fact had a public engagement process. We've held forums in 30 different places throughout the state. And we knew our natural allies would be people in the other cities, in some of the suburban districts like Yonkers and Wyandanch and all. But what's become very interesting is our case is being tied in with the future of these learning standards. And we get people in Westchester, we get people every part of the state who are seeing that what's at stake here is, are we going to have educational standards that are meaningful for the 21st century, and is the state going to back them up or not? And to some extent, that's what this case is now about.
I think another interesting that's come up that is not directly related, we shouldn't criticize the state for who it hires, but it's interesting that one of their major law firms representing them is a group of Southern attorneys who have been representing much more, quote, backward states on this issue. And why was that? How could they engage that? That seems to be a throwback to the times of fighting desegregation.
Well, in fact, this Southern firm they've gotten, Sutherland, Aspel, and Brennan out of Atlanta, Georgia, has not been gaining its experience in fiscal equity cases in those states. Their experience is still in desegregation. They're
fighting
premier law firm in the country for helping states and cities in the South and the West who want to get out from under desegregation decrees do so. So we were astounded when the former Attorney General, Mr. Vacco, brought them in. He brought them in at a point in the case where the judge had made it clear that he was serious about going to trial, and after years of delay on discovery, the case had to move, and I gather Mr. Vacco thought he needed help. And I wouldn't argue with that. And by the way, CFE, we're a small not-for-profit. We needed help too, but we got it from a premier New York City law firm, Simpson, Thatcher, and Bartlett, that were willing to take this on pro bono. The Attorney General saw fit to go out of state to this Southern law firm. They, by the way, paid them $5 million so far, and the tab is running as we speak. But what was interesting is when they brought them in, and we opposed this. This is the first time the Attorney General has retained an outside firm. And we said, why do you have to bring in an out-of-New-York State firm? And he said they have national expertise and a national reputation in education law. And that's when we looked into it and found out, yes, they do. They're good lawyers. But their expertise is not fiscal equity. It's desegregation.
And it's a terrible idea for New York. But let me get off my high horse. Let's talk about some of the arguments against this whole strain. And one of them is, I guess they fall into two categories. First of all, something the New York Post has trumpeted the fact that when you work it all out, we're expending $11,000 per pupil in the city of New York. Why can't that be enough? Isn't this a matter of inefficiency, not a matter of money? How do we confront those kinds of arguments?
Well, first of all, I don't know where I think I read that also. I don't know where the New York Post got that statistic, and I have to check with my board, but and our members, and you're one of them. But I'd almost be prepared to say if they could guarantee $11,000 a student, maybe we'd take it. I mean, our figures, the latest audited figures from the state, are about $8,200 for the city. That is 2 years behind. It may well be in the low 9,000s, but it's not 11,000. But in any event, the larger issue here about inefficiencies in New York City. Look, I'm not going to pretend that there may not be more efficient ways that the Board of Education can go about things. In a system this size especially, there's always going to be some corruption that's going to come to the fore. But our position is, first of all, I'm in the fortunate situation of representing the public school children and not the Board of Education. So we've said to the state, if you know of any major ways that this system could be more efficient, let us know. Put it on the trial record. I mean, we have no brief here for inefficiency. We're not looking to get money for the sake of money. But the larger question is, I think when we're talking about major reforms that are necessary, like bringing class sizes down from 28, 29, or 30 to 20 or 21, we're talking about finding ways to attract enough qualified teachers so we don't have 14% uncertified teachers. When we're talking about the billions of dollars necessary to repair our facilities and get decent buildings in this city, these so-called inefficiencies, quite frankly, even if you point them out, they're going to be minor in scale. So let's face the real issue.
Well, talking about that, how do we go to parents of upstate children and say, if these guys in the CFE case win, my kid's going to lose? How do we have that conversation? This is a state. We're all part of it. I don't think certainly I don't feel, I'm not attacking the kids I know up in Buffalo. I've spent enough time in Buffalo and Elmira and even in other parts of the state. How do we talk about an equitable system that ultimately the parents up there don't necessarily feel that they're getting enough for their kids?
Well, as I mentioned earlier, both because of the way the case developed from that Court of Appeals decision and on the basis of a strategic decision that was made through conferences we had a couple of years ago with all our constituents in New York City, we did make a decision that we were not going to ask for what's known in some of the other states as a Robin Hood remedy. Because we've seen in Vermont and California and some other places this tears the body politic apart. If you say you're going to take money from the rich districts to give it to the poor districts, you have a political battle on your hand of major magnitude. And we've got enough we're dealing with. And I think it was fabulous wisdom. You don't, as you know, David, it's very hard to get the education advocacy community in New York City to come together on any controversial issue. But we had virtual unanimity among 100 groups in the city on this, that we're going to look to level up, we're not going to look to level down, and we're not going to ask to cap the affluent districts. We think we have a constitutional right to bring New York City kids up to a basic adequacy level. And we think that level is something like the current learning standards. So we've got a long ways to go, and that's a big battle. We're fighting that, and we've done it in a way where I think we've gotten a lot of support upstate, even from quarters that you might not expect it. If you put people at ease and we say to them, we're not pulling down what your kids have, but we think you have a moral obligation and a legal obligation to support kids in the inner city that are far from there. And it may mean income taxes are going to rise for residents of Scarsdale and some other places, but I think they're willing to accept that kind of thing if you're not threatening their own kids, and that's the way we're going about it.
What about this more broader issue? I mean, this case is, as you've mentioned before, part of a much broader problem that's going on in the nation. What is the ultimate solution for this? I know there was, in 1977, there was a famous Supreme Court decision where I think Thurgood Marshall had a dissent where the constitutionality of essentially equal opportunity to education was decided by the court not to be something that was protected. And Marshall, if I remember correctly, said this was a major turning point in the democracy. What should people be looking at as a question of this on the national agenda?
Well, it's very interesting that you raise it. I think that's the Rodriguez case you're referring to, and that really started this whole fantastic movement in the state courts, because the federal government or the federal Supreme Court wouldn't take it on. The court basically said, we don't argue with the facts that these funding systems in virtually every state are inequitable, but it should be handled by the states. And the state courts have been handling it. Interestingly, Marshall did have a very perceptive, long dissent there. And a lot of the themes we're now coming around to, of trying to find judicially manageable standards through the learning standards that the regions have, of coming up with some concept of a core adequate education, those were the things Marshall was talking about in the 1970s. So to some extent, it's taken us a while to develop these doctrines in the state courts, but that's where we are. What we've got to do is spell out what adequacy means, and the regions have helped us with these learning standards. And once we do, then I think we can really focus on what the state's obligation is to make sure that all kids get that opportunity.
It was interesting, we were talking before the program started. I had a brief meeting with then candidate Clinton years ago because of our relationship from school, which you have too. And we had this discussion on a report that Community Service Society was then working on, which looked at what was called teacher assignment, the fact that kids were not getting equal opportunity to qualified teachers. And I remember Clinton saying, you know, he understood it. Arkansas had a real problem with it. And then I got very excited, as most advocates, particularly when they're still naive, did. And I said, if you become president, will you make this a major stake and part of your bully pulpit, educational equity for all? And I remember Clinton, one of the real educational experience, turning to me and saying, absolutely not. Look what happened to Jim Florio. But I'll tell you what, if you create a national movement, I'll certainly be there. And it's almost prophetic, the fact that this has died as a national issue and how an incredible impact it's had in shaping the kind of America we have. I'm still, as I start to look through it, issues of resegregation of urban and other areas, which is occurring now. You know, residential segregation, I think, is bad now, as someone told me, as in 1954. And almost all of it, when you pry below it, is not a matter of segregation because of race hatred necessarily, but on the issues of education. People are fleeing neighborhoods, not because they don't like urban environments necessarily, but there is that, but they're fleeing towards what they perceive of as better schools. And if we had stopped playing games about it earlier on, instead of this stupidity we're in, I don't know what the rollout is going to be of this thing. It certainly reshaped America based upon this issue.
Yeah, well, I think, you know, very interesting to me that you mentioned that Thurgood Marshall dissent. That Rodriguez case was a 5-4 decision. And if it had gone the other way, as you're saying, in 25 years ago, we had a strong position on this from the U.S. Supreme Court, our history on urban America may have been very different. But fortunately, the state courts have picked it up, and maybe it's 25 years later. It also may be, David, that our systems needed the time to develop education standards, to develop concepts of funding education. There's been a lot of experimentation going on. We've learned a lot from what's going on in other states, and you know, in New Jersey, they had a decision, it was one of the first ones after that Rodriguez, that the court ruled in favor of the plaintiffs, but it's taken them literally 26 years to hammer out the remedy. We don't expect to take 26 years in New York. We expect to learn from New Jersey and all the other states. And hopefully we can pick up the steam on this, and I don't think it's too late to revitalize education in urban America. And I very much hope that our case will be one vehicle for doing it.
It's interesting. I think I am hearing more people who recognize, and I think it's a combination of the new technologies that are coming, that are sweeping down on all of us. Certainly as somebody who's now past 50, you know, even comprehending the internet has become quite an achievement. But I'm getting to understand that people get it, at least that the current sort of one-room schoolhouse approach to education just doesn't fit with the next century.
Yeah, by the way, when you mentioned President Clinton and the national approach on this, to give him some credit, I guess, you may be aware that there just earlier this fall was a major summit meeting convened by IBM where they brought together the governors of most of the states, CEOs of about 50 corporations, and President Clinton was there. They had actually gotten together in 1996 and done something similar, and this was a follow-up. And the major decision that was made in '96, because we studied this in some depth, the standards movement had bogged down on the national level. And to some extent it was because Clinton had gone pretty far out on certain aspects of it, and then he got that Republican Congress, and the whole thing got bogged down in politics. So what Lou Gerstner, the head of IBM, tried to do, he gave a challenge to the governors at the Governors Association thing, and he said education reform standards are too important to be bogged down in politics. If you guys will come to a summit meeting, I'll invite all the chief CEOs. I want the governors there and the president. Let's see if we can get this going again. And the commitments that were made there was to take this seriously on the state level and not get it bogged down in national politics. So I think there has been some follow-through on that, and that's where we are with this.
No, I saw Clinton's comment to me basically as being a political realist. I regretted it because I think that it might have been an interesting, at least to take the bully pulpit of the presidency and make that something that you could leave behind as a legacy. I know we shouldn't talk about legacies, but I think having grown up in Bedford-Stuyvesant, lived all my life in New York, and a couple of blocks from where I grew up, and watching the continued deterioration of the schools that I went to, which we didn't think was possible then. I went to a segregated school, PS 138, the number per diem and substitute teachers, no delivery of books, all the stuff that led my parents, who had some resources, to get me out. I visited there some years ago, and if anything, it's deteriorated further. Wow. And that's like 20 years of miseducation. And there are a lot of sort of, if not villains, a lot of people who contributed to it. And I guess it becomes somewhat disappointing when we see the recent spat of news reports with 8th grade tests and 4th grade tests showing extraordinarily high failure rates in particularly very poor neighborhoods, and how those kids, even if we come with the emergency trucks quick in terms of the money we're talking about, how are they going to participate in the economy? And well, I'm not, you know, this is not the end of the world. I do think there's going to be the next step after getting the money shaped up is obviously what the conservatives have been so effective in attacking us about. We have to find a better way to manage resources and make it happen for all the kids, because there's been a lot of steering that's going on here. And it's natural. People are going to fight for their kids first, but I don't think it serves the city particularly well. What about, as you look around other potential lawsuits that has anything else emerged as potential other challenges that are coming out of this?
Well, I must say we're involved in a trial situation that's probably going to be going on 6 months before we're through. So we feel like we've got our work cut out for us. But there is a lot of work to be done in other areas. There's a lot to be done in the CUNY area for sure. But I think we'll bide our time and see where we get with this one first.
Well, in terms of the CUNY area, I think I think a lot of us are saying clearly everyone's made the point now, and as a matter of fact, on both sides of that debate, that it's the public education system driving the kids into the CUNY system without, quote, adequate preparation. That's the real issue. This looks like passing the buck a bit, yeah. But you know, clearly that has to be connected as we go ahead.
Oh, there's no doubt about it. And the proportion of New York City school graduates that need remedial courses at CUNY is a fact that we've brought to the judge's attention in our trial, and I think it's a very relevant statement. Kids shouldn't be getting remedial courses.
And did the defense have an argument with that, since they
haven't heard it yet.
Some of the now this should be interesting, since don't they appoint a number of the SUNY and CUNY? I think you may have to have witnesses from the other side. I mean, they've been making the complaint left and right.
Right. Well, Benno Schmidt is scheduled to testify and give us his insights on this, so we'll see where we get with it.
Well, thank you very much. Taking from the poor to support the rich, the state for years has been enriching suburban schools at the expense of New York City students. The gravy train may soon grind to a halt as the court takes a tough look at the practice. Hopefully, in the not-too-distant future, city students will enjoy equal footing with their peers elsewhere, getting the resources and support they need to achieve a sound basic education. This is David R. Jones, thanking you for joining us on the Urban Agenda.
To comment on the Urban Agenda or for more information on CSS, contact Community Service Society of New York, 105 East 22nd Street, New York, New York, 10010. Area code 212-254-8900.